Hello, and welcome to another edition of Think Like an Attorney. This is a podcast which is dedicated to all things law and all things lawyers. Today I have as my special guest Abraham Lincoln. He may not be saying a whole lot, but he's pretty much said it all through history. One of our finest presidents ever, and an even better lawyer. Today I'm going to discuss a particular topic which came up in the news media regarding my alma mater, Mitchell-Hamline Law School. In my day, it was William Mitchell College of Law. I graduated in 1985 from that school. The new dean was installed a few days ago and gave a speech regarding a certain topic which I think is going to be the discussion today. The basic idea and the basic title of this topic is disposing of the bar exam, really? So I think you can probably tell what my position is going to be regarding this, but first of all, I'd like to kind of give you an idea of the actual controversy at hand. This is a couple of things I'm looking at. Is number one is a Fox 9 report, our local station, discussing the actual installation of Dean Nidwicki. I'm probably mispronouncing that, and I apologize if I have, but the dean is attempting to hammer down one of the oldest pillars of law. Quote, "I think the fight to stop the bar exam and doing something different with licensing is very important," he said. He feels that the bar exam doesn't prepare people to be good attorneys, and he basically says that he wants to eliminate the bar exam itself. His basic indicators for this is that he believes that the bar exam is essentially racist. So my point here is that I want to discuss is that as a former alumnus of William Mitchell Hamline, essentially, is that in regard to the bar exam, I feel that the bar exam is absolutely essential as a proper bar, a proper gate, a proper requirement before anyone is entitled to the coveted and very important idea of licensure as a lawyer to appear in our courts. This is important because the licensure allows an expert in the field of law to actually represent clients, and these clients only get one chance in the courtroom, and they must have the best of the best representing them. The bar exam, as I look at it, is a crucible. For those who aren't really sure what a bar exam is, it is basically a two-day crucible, a two-day test in which we have to essentially answer lots and lots of questions. The first day is all essays. The second day is 100 multiple choice questions in the morning and 100 in the afternoon. By the time you are done with the bar exam, you are spent, you are exhausted. It's that great of an ordeal, but it is a necessary ordeal. As I look at it, it's like the old JFK quote when he talked about going to the moon, and I'm paraphrasing, but he said, "We go to the moon not because it's easy, but because it is hard." The bar exam is hard. We want to be lawyers because essentially it's a really hard undertaking, and it distills it down to just only the elite can practice in front of a judge and a jury. So because it's hard, the bar exam itself is going to really challenge an individual on what they have learned over their past several years in law school. The idea of getting rid of such an exam and such a great test of ability it flummoxes me. I don't know how one can say we just simply get rid of the bar exam and this will solve all of our troubles. If we're going to get rid of the bar exam, why not get rid of all examinations in school, in college, as well as law school? Why don't we just feel our way to a degree in our expertise instead of actually taking competency tests? The idea of the bar exam is to protect the public. That's the final meaning of taking an examination and successfully passing it, that now you're capable or will be capable of representing the public who only get one shot in that courtroom, as I said. The bar exam is carefully calibrated to test the student's knowledge of core courses. Our state bar examiners figured it out a long time ago as to what competency is and what is necessary for admission. Again, when we talk about the law, and the law itself is a business, and law is a tough business, the bar exam is a gate through which we can only pass to become a member of such a very difficult and tough club. Think of the layout of a courtroom. The courtroom has the judge's bench. The courtroom has at the back the gallery. But in between that gallery and the court bench and the well of the courtroom, where the lawyers sit and where witnesses are called, there is a bar, an actual physical wooden bar with a swinging door. The idea is that only certain people, only the qualified, are allowed to pass that particular bar in that particular courtroom. Not just anyone can get into the well of a courtroom, and with good reason. I remember one of my bar instructors for the bar exam itself was a great lawyer here in Minnesota and practiced in St. Paul, and he was an excellent lawyer. And he likened the bar exam to the NFL. So bear with me. It's the rookie experience of the NFL. Every rookie has to go through it. The veterans would mercilessly hit them from behind and from the front and knock them senseless for their very first time in an NFL game in front of a nationwide audience. The rookie would be knocked to the ground, and that very opponent that knocked him silly would extend a hand to him and help him up off the ground and say to him, quote, "Welcome to the NFL." I think we have to keep in mind that law is very similar to this type of idea. It's a great metaphor. The bar exam is when the state of Minnesota lays a hit on you that knocks you senseless. And if you can get up and if you can recover from that, then you're worthy to be a member of the bar. Maybe if individuals cannot pass the bar exam, maybe it's just not for them. Maybe it's a situation where those 4 years of law, learning the law and study weren't really for them in the first place. And it's best to weed them out now. It's a weeding out process in a lot of ways. The concern that I've got is that William Mitchell, or Mitchell Hamlin, I looked at their course curriculum and all their courses. They have no courses specifically dedicated to the bar exam. Yes, they have the core courses we all have to learn, which are tested on the bar: contract law, torts, constitutional law and liberties, criminal law and criminal procedure, property law, and so forth. All of these things you must be conversant in if you're going to pass the bar examination in the state of Minnesota. But how to take the exam, how the techniques of frankly beating the exam are never taught to anyone in law school. My view and my solution is that part of the problem is the law schools themselves. They should dedicate, before a student graduates, in the several months before the last semester before they graduate, to have a bar review course. For 5 straight months, they should be taught the ins and outs and the best techniques and strategies for passing that all-important test. Right now, as it stands, they simply graduate the student, and then the law school, not unlike Pontius Pilate, washes their hands of the entire thing. Their student is done, the tuition's been paid, and they leave it to the prep course people that only give them basically 60 days before the examination occurs. You graduate in May, the exam is in, you barely get your breath, the exam is in July. And there was a discussion that the bar exam prep courses were too expensive, which I think was indicated by the dean in his address, and that it may be cost prohibitive. It's nothing like the cost, however, of students going into 6-figure debt after 3 years of law school. I think the least that law schools can do is have a semester out of the number of semesters you teach, to have a semester dedicated specifically to teaching students how to pass that all-important bar examination. The other point that I want to get across is that the bar exam prep courses are very good. I'm not dissing those. I'm not trying to eliminate those. But the bar exam prep courses are great. I remember when I took my prep course that in the prep course, the professors were stellar. They knew exactly what to teach, and they got right to the raw law, the bare bones law, and basically the least you need to know. And suddenly everything came back to me, and I understood what was being said. The second point was that I wanted to basically kick those old professors in the back of the pants because they hadn't taught me the important things I needed to know. They were too busy with Socratic examination questions. They were too busy with hypotheticals to spoon feed us the law, which I think is in any bar prep course, be it in law school, which I advocate that law school should do, or in a prep course afterward, that you must spoon feed the law because of time constraints to the student so that they know what to do. The other thing that we kind of have to keep in mind here is that I knew a friend of mine that was a guy in law school that took the bar exam, took the prep course, really studied like hell. And what had happened was he took the test and failed. And he failed it by a point. He was crushed. The failure of a bar exam is soul crushing, bone crushing. You don't know if you have the stones to be a lawyer. It casts great self-doubt on an individual in that regard. The only thing the individual can do is take the exam again. The only thing the individual can do is take the prep course again. And that's exactly what this person did. That guy, he took the test, the practice tests. He worked on Saturdays, taking an extra course, just simply doing practice tests on Saturdays. He found every question he could find in order to prep himself and to get into test mode. He also doubled down on the studying of the core itself. Well, I'm happy to say that that particular guy took the exam again and passed with flying colors. Other part of the story, that guy, that was me. I failed the first examination and took it again. I got knocked down and got up again and took the exam and passed it with flying colors. I didn't blame the test, which is what the dean is doing here. I beat the test. I studied harder. I did the extra work and put in the extra time to beat that test. And I think law schools need to teach those students how to beat the test. It is a fact of life. The other thing about the bar exam itself is, and there's been talk of racism and diversity in his particular speech, is that the law school is, the bar exam itself is diversity in motion. It tests these students' abilities in 3 different ways. One are multiple choice questions. You'll get a long question with 4 or 5 choices, and you must choose the best answer. 100 questions in the morning, 100 questions in the afternoon. Then the second day is essay questions in the morning, which are essentially long story problems, which require a student to basically identify issues, not unlike an Easter egg hunt. You've got to find all the issues, and then you've got to apply those issues and the law to those particular issues, to apply the law that you know to the issues, and then tell your examiner in the particular examination who wins and why. In addition, there is a multi-state performance test requiring the examinee to handle a lawyerly task. Essentially what happens is the examinee is given, you must draft, based on this set of facts, a memo. You must draft a memo to the boss. These are 3 individual formats. They are all different from each other, but they do involve a vehicle of redundancy. This is deliberate. Some students might be better at one type of question area. Some people may be worse at others, but it gives everyone a fair shot in multiple formats to express their ability and prove their ability in a proving ground known as the bar examination. In addition, model answers are given. A model answer is the perfect answer. Well, what happens after the bar exam? They have to be graded. The multi-state examination, which is multiple choice, is easily graded by computer. There's only one right answer. essay questions and the boss memo, those are a little bit more tricky. And this state, the state of Minnesota, the Bar Examination Office, basically allows and recruits volunteer lawyers to work on Saturdays and at nights to grade these darn exams, and to do so within 60 or 70 days. These are great lawyers. They are diverse lawyers. They meet with each other and they look at a model answer for each question, and then they will grade that question and then pass the question on to the question and answer, the student booklet, to another lawyer. By the time the student gets a final grade, 2 or 3, maybe 4 lawyers have actually looked at the grade, looked at the examination booklet and the answer given, and graded it accordingly. Then there's an average of the grades. And this is how it's determined as to whether or not you pass the examination. So diverse lawyers, diverse questions, diverse format. Thousands of students and thousands of examinees have taken this examination, and it works. The key thing to keep in mind is, again, protection of the public. We do this and we make it difficult in order to get only the elite practicing before a judge, because so much is at stake. You must have an expert. Prison time could be at stake. Hundreds of thousands of dollars can be at stake. Parental rights may be at stake. This is why it's so important to have only the best of the best helping us in terms of representing individuals and giving us some true advocacy. The final point that I really want to get across here, and it's a challenge, is that I looked at the Dean of William Mitchell and looked up his resume, and I noticed that he's not licensed in the state of Minnesota. He is not a licensed lawyer here. And maybe that's not necessary for being a dean of a law school. But I challenge the dean, maybe before you condemn it, you should try it. Maybe you should take the examination yourself. I'm sure that the state bar would allow you to sit for the bar examination, and let's see how you do. And more importantly, you can report back to us what you feel the inappropriate questions are, how unfair the exam is, and why. I don't think you can just take a big, broad, sweeping brush and tell us that the bar exam is unfair and racist without you doing it yourself and going through the process yourself. So that would be my challenge to the Dean of Mitchell-Hamline. Here's the takeaway. The Minnesota bar exam, it works. Keep it. If you like this particular podcast, I'd ask you to please notify, subscribe, and like if you can. That's always helpful for our channel. Thanks again for watching, and remember, think like an attorney. There is no substitute.